My name is Emmanuel Ovekbose. I'm the PRO and a rent officer at the Rent Control Department of Ghana. So Rent Control Department, as the name implies, it has to do with rent, the control, and the department. So when we are talking about rent, the act referred to as a recoverable rent, which means it can be recovered monthly or frequently. So the rent or the recoverable rent is the money that is paid by somebody to occupy somebody's premises. So when the tenant pays money to the landlord, we call that money rent, or the money that is collected by the landlord from the tenant, we call this rent, so that the landlord can give his premises for a particular period of time to the prospective tenant. Then the control is the guidelines or the management of this money that is paid. Then we talk about the department. The department is more like an agency that has been set up by the government to make sure that the money that is paid by the tenant to the landlord is legal, and then it follows the due process as it is stipulated by the Rent Act as Act 220. So in effect, the department is more like the officers that has been assigned to make sure that the money that is paid to landlord are on the right direction. So as a tenant, you have your rights and responsibilities. There are issues that may crop up in the premises that you first have to deal or sit down with the landlord and discuss. If there is no amicable solution, then you can fall on the Rent Control Department. And some of the issues that you can bring to the Rent Control Department is when the landlord is charging you more than the recoverable rent. As I mentioned, the first point of call when a landlord or somebody builds the premises is to apply for what we call an assessment. This assessment is where we will come, ascertain and look at the premises, look at the materials you use, look at the location, look at the security, look at the property rate you pay and all those things. And this will aid us to determine how much you have to charge your premises. And we do this assessment every 2 years. So as a tenant, if any landlord is charging you more than the recoverable rent, and you've discussed it and the landlord does not agree with you, you just run to the Rent Control Department. Secondly, any tenant who induce you to vacate your premises, the law forbids any landlord to induce any tenant to vacate the premises. So if any landlord is inducing you to vacate your premises, you have the right to come to the Rent Control Department, and then we look at investigate the issue, and then see if the determination can be made. Also, when a tenancy agreement is signed and the landlord does not adhere to his portion of the tenancy agreement, you also have the right to come to the Rent Control for us to sit the two of you down and then make sure the necessary thing is done. So these are some of the issues, and then we can talk about refund. Refund is when you live in somebody's premises and due to some circumstances you are moving out where your time is not due. In that case, you made some advance payment, and then what we call the refund has to be made to you. Maybe the landlord has promised you severally and is not giving you the money. You can run to the Rent Control Department. We will bring the landlord, do necessary investigation, and then press on the landlord to give us a specific date or necessary where the money can be paid. So these are some of the issues that tenants come to our office with, and then we try to assist them. Okay, so most landlords, because they are doing illegal thing, the illegal thing here means they are charging more than the necessary recoverable rent. And then when they see that you sign an agreement with them and your time is not due, they do all sorts of things for you to vacate the place. And this is what we call the inducement. They put so much pressure on you for you to be fed up and then move out, so that he or she can get another person to come and occupy where he will have the chance to increase the rent, because you are mandated to pay within the assessment period, that's the 2 years, what the rent control has specified for you to pay. But because you are in the house, they want to vacate you and bring a new person to come and occupy the place where they will have the chance to increase the rent, which is illegal. So this is the inducement that most of the landlords do, just to make sure that tenants move out from their premises. So as a tenant, if you have any grievances with your landlord, the first thing you have to do is to sit down with your landlord and try to have an amicable solution. If that fails, then the next point of call is not the police, it's not the strike, but it's the rent control department, where you come and then first of all we listen to you. If it warrants that we have to give someone to you to be given to the landlord, we do. If it has to do with an advice that we advise you for you to go back and seek and stay in amicable settlement with the landlord, we do. But when it comes to giving you a sermon, what we do is when you tell us your story, we put it on paper and then give you a copy, or what we call a sermon. Then we give you a copy to be given to the landlord, because for now we don't have bailiffs. So we use you, since you have fair knowledge of the landlord, we give you the paper to be given to the landlord, where we give you a date for the two of you to come and meet the rent officer. So on the set date, we listen to you again, we listen to the respondent being a landlord or a tenant. So we listen to the two of you. If there's the need for us to bring a witness, we do. If there's a need for us to request for further document, we do. So when we do that, then based on all the evidence, all the documents available, we adjudicate the case and then make determination. So this is basically the process that you follow as a tenant if you want to bring an issue for us to help you at the rent control department. Yes, so as a complainant, when you are coming to make a complaint at the rent control department, all documents available must be in your hand. We have 4 basic documents. The first one is the rent card that all landlords are mandated to give to tenant within 7 days after the tenancy has been signed. The next one is the tenancy agreement itself, where the obligations of the tenant and the obligations of the landlord are stipulated, and any other requirement. Then we have what we call receipt of payment, the money that you pay to the landlord. The landlord should have given you a receipt instantly when you made the payment. So when you are coming to make complaint at the rent control department, you should have all these documents with you. We will also listen to the grievances that you bring to us. We'll put them on the paper, get the document that you have, invite the other party, being landlord or tenant, and then give you a specific date for you to come for us to listen to the two of you. As you mentioned, there's a fee that you pay, but the fee varies from issue to issue. So as a landlord, or as a complainant, there's a fee, as I mentioned, which you have to pay, but it varies on the basis of the complaint that you bring to us. So first of all, the document that you were given by the tenant, by the landlord, needs to be brought, and then the appropriate fee has to be paid for us to give you the summons to bring the other party, for us to determine which case, based on the law, where we have to put it. Okay, so when you get to the rent control department, there are various charges for various complaints. So when you get to any rent control office, based on your complaint, they will tell you specifically how much you are supposed to pay for that particular complaint. So to solve a rent control issue, we have a mandatory period of 2 sittings. The 2 sittings may vary. Basically in general, it's 2 sittings. 2 sittings can be within a month, but there are some cases that take longer time. For instance, when a refund is supposed to be made by a landlord to a tenant, based on the economic situation, we give based on what the landlord will tell us, it may take 1, 2, or 3 months based on the quantum of the money. The same way, if the tenant is owing a landlord, and that's what we call rent arrears, it depends on what the tenant will, based on what he does. Then we ask the tenant to spread the money between 1 to 3 months. So if it's a general issue, like evicting a tenant, it takes within 2 sittings. Sometimes within the first sitting, when all evidence has been declared, we just give the tenant a date to vacate, which means just 1 sitting, the case has been adjudicated. But when it comes to a time that we have to collect the rent arrears from the tenant, or we have to collect the rent arrears from the landlord, then sometimes it takes longer period based on when the monies will be available. So there's no specific duration as to when a case will be adjudicated, but it depends on the merit of the case. So the number of rent officers that sit on a case is one rent officer per case. Currently, we have 55 offices across the country, except Bono, Savannah, and then the Afo. That's Bono is Afo, and then Savannah. Apart from these three regions, we are scattered all over the country with 55 offices, and we have 65 rent officers. So a rent officer sits on a particular case. We don't shift cases from one rent officer to the other. When the case comes, a rent officer is assigned to take care of it. So if it takes 3 months for that case to be adjudicated, it's only that rent officer who is assigned to that case. So each rent officer sits on each case. So when it comes to enforcement of our orders, the Act mandates us to determine a case and then make recommendation and then give orders. So the order is what has been mandated by the Act. So when you come before us as a landlord or tenant and we adjudicate the case and we give order and you flag that order, it constitutes an offense where then we will have the right to line you up before the magistrate and then make our recommendation and then for the magistrate to implement. Any person who flouts any aspect or who contravenes any of the Act has a mandate, or the rent magistrate has the mandate to prosecute you, and the offense will take you to a 6 months imprisonment maximum with a minimum of 3 months. You can also be charged a penalty unit of 100 unit maximum, and then 100 penalty and 50 penalty unit minimum. The 100 penalty maximum is equivalent to 1,200, where the minimum of 50 is equivalent to 600 Ghana cedis. So the judge, upon our recommendation, can bring the two together, which means the fine and then the prosecution, that's imprisonment, or he can just choose one and then impose it on you. So it will all based on the discretion of the magistrate. So when an offense, when you give an order and you don't adhere to it, then we have the chance to take you before the magistrate with our recommendation for the magistrate to implement what has constituted the offense under the Act. Basically, when you are coming to rent control, you have the option to bring a lawyer or not. The place is so flexible that without a lawyer, we can assist you to bring your case down. But if you feel so detergent or you don't have the strength and you prefer to bring a lawyer, the law mandates you to bring a lawyer to come and speak on your behalf. But in effect, you don't need a lawyer to come to the rent control department if you have an issue. So there are issues that we refer to the magistrate or the court. The first one is what we call the abscondment, where I explained that if a tenant comes to your premises and his time is due and he vacates the premises without giving you back your key, you, the landlord, has no right to force opening the premises. As a rent control department, we also don't have the right. We have to refer the case to the magistrate. What we do first is we give a notice of 2 weeks on a written paper for the landlord to go and paste in front of the premises. And within that 2 weeks, if the tenant does not appear before us, we go to the magistrate or the court and get order for us to force opening the premises. When we force open the premises, we list all the items that we find there. And then we give a copy to the landlord, we keep a copy. And the items itself, we give them to the landlord for a safekeep. For a period of another 2 weeks, if we still don't get the tenant or the absconded tenant, we go back to the magistrate again for the magistrate to guide us on what to do with the items. Either we should send it to the SOS, we should sell and put the money in the consolidated fund. Also, when we give an order, just as I mentioned, and the tenant or the landlord does not adhere to it, we cannot take you straight to court, to police station or any other place. We line you up, or we take you before the magistrate. We give a recommendation as to the offense that you've committed under the act for the magistrate to implement any other sanction that. So these are some of the issues that we refer to the magistrate for the magistrate to give its final judgment. So the order of the rent officer has a very legal effect, in that when an order is given by the rent officer and you don't adhere to it, it constitutes an offense. And this offense is what we put in a paper and then attach a recommendation to it and hand it over to the magistrate for the magistrate to implement. So as a rent officer, we don't have the right to prosecute you and then fine you. The law does not mandate us. What we do is to make a recommendation before the magistrate, prosecute you before the magistrate, and then allow the magistrate to implement the offense, or to prosecute you or to fine you as to the offense that you committed under the act. Under the Rent Act, any person who comes before the Rent Control Department has the right of an appeal. The right of an appeal is in that when a rent officer sits on your case and you are not satisfied, you then have the right to go before the magistrate with all the evidence or with all the rulings that the rent control officer has given you. And the rent magistrate will either refer the case back to the rent control officer for further investigation, or the magistrate in his or her own way can go through the system again or go through the investigation again and then make a determination. So as a complainant or as a respondent, if you come before a rent control officer and adjudication is made, and you are not satisfied, you cannot just sit there. You have the right to go before the magistrate. You can even go as far as the Supreme Court to make your case be heard if you are not satisfied at the magistrate level or the commercial or any other level of the court system. Okay, so under the Rent Act, that is the Act 220, there are laid down procedures for landlords, there are laid down procedures for tenants. And the Act is there to support both landlords and tenants. But when we come to Section 17, Section 17 is the recoverable rent or ejectment. There are laid down procedures as to what a landlord can do to get his property back. The first of it is that the law mandates that no tenant has the right to owe any landlord more than a month's rent. So if you are a tenant and you are owing a landlord more than a month's rent, the landlord has the right to apply for what we call order of eviction. This means that no landlord, no matter how offense the tenant has committed, you don't have the right to force and sack the tenant from your premises. What you need to do is to apply for this order of eviction for us to investigate and then assist you in getting your premises. Again, when you look at Section 17(1)(b), it says where an obligation of the tenant other than specified in A so far constitutes a provision of this act has been broken. Simply what this means is when you sign a tenancy agreement and your part as a tenant, you don't strictly go according to it or you flout any of your obligation, the landlord has the right to apply for this order of eviction. Also, where the tenant or any person residing with him is found guilty of a conduct which is of annoyance or nuisance. So as a tenant, you don't have the right to cause nuisance in somebody's premises or cause annoyance to adjacent occupants or adjacent tenants. If you do that and you are spoken with and you don't stop, the landlord has the right to come to the rent control office and apply for this order of eviction. As a tenant, you don't also have the right to use the premises for immoral and illegal purposes. This also constitutes an offense where the landlord can apply for this order of eviction. And then where the condition of the premises, in the opinion of the magistrate or the judge, is deteriorating. So as a tenant, you have an obligation to make sure that how you go and meet somebody's property, you make sure the place is the same. But when it's found that you are deteriorating based on neglect or based on the default that you don't look at the premises well, the landlord has the right to apply for this order of eviction. Or where a situation happens that your time is getting due as a tenant, and you give notice to the landlord that, no, at the end of my period or tenancy, I'll be moving out, and the time reaches and you are still there, you've caused just an offense, let me put it that way, because giving the notice to the landlord will make the landlord also go and contract somebody to come and occupy the place. So when the time reaches and you are still there, the landlord has the right to come to the rent control office and then apply for this order of eviction. So these are some of the support that we give, or the Act gives to the landlord. As I mentioned, there are others that where we mentioned for the tenant, there are other support that the Act gives to tenant. Just like the landlord has no right to increase rent, to induce you to quit. So these are some of the things that support both landlords and tenants. But what I've mentioned earlier are some of the support that we give to the landlord according to the Rent Act. When an offense is committed by a tenant in a premises, the law gives guidance to how the landlord can use to evict that tenant. The first point is that you have to sit down with the tenant and try to come to an amicable solution. If that fails, then as a landlord, you come to the rent control department, tell us your issue. If we see that the issue constitutes an offense, we give you a summons to be given to the tenant, where we invite the tenant, investigate it properly, and then give an order if it's necessary. So the first issue is that as a landlord, you sit down with the tenant and then try to solve the problem. If that fails, come to the rent control department with your issue. We look at the issue. If it warrants that we have to invite the tenant, we do it, and then sit the two of you down, listening to both of you, and then we investigate and make a determination. Okay, so if you look at our 2019 statistics, we have it clear that 72% of tenants were not able to pay their rent, of which landlord has brought them and applied for the order of eviction, which means based on the economy we are facing now, a lot of tenants are not being able to pay their rent. So this is very practical that most tenants are not being able to pay their rent. And when we come to the side of the tenant, a lot of landlords are inducing tenants to quit from their premises just for them to get access to their premises and then bring new people where they can increase their rent, which is illegal, as I mentioned. Because before you increase any rent, you have to apply for what we call the assessment. And then after the assessment, we give you an assessment certificate where it's only the rent control officer or the rent magistrate who has the right to increase rent in Ghana. So these are two main issues that tenants bring to our office based on inducement for them to quit. And on the part of the landlord, it has to do with tenants who are not being able to pay their rent to the landlords. So landlord legally can stand under Section 17 to evict a tenant. Apart from that, there are some offenses under Section 25 that also warrants or that gives the landlords the power to apply for what we call the order of eviction. I'm stressing on the application of the order of eviction to battle the point that no landlord has the right to forcefully evict any tenant from his premises. This means that any offense that a tenant commits, any offense that you think a tenant has committed, you don't have the right to raise a gun on the tenant or go upstairs and then remove the roofing of the building or seize the tenant from enjoying electricity, water, and those things. What you have to do is to come to the rent control department, apply for this order of eviction, where we invite the tenant and ascertain whether an offense has actually been committed. So when you look at Section 17 again, the tenant has no right to owe the landlord more than a month. You have to abide by the tenancy agreement that you signed as a tenant. You don't have to cause nuisance and annoyance. You don't have to use the premises for immoral and then illegal purposes. You don't have to let the place deteriorate. And then you don't have to give yourself notice that I'll be vacating where you know that you can't do it. If you give a quick notice to a landlord on a specific date and you are not able to do it, the landlord has the right to stand on that and then evict you. So these are legal things that the landlord can stand on. And then I have to point it that no landlord has the right to evict any tenant and then bring in another tenant. The law does not permit you. If you evict any tenant and you want to dwell in personally, fine, or your family want to dwell in personally, fine. But you don't have the right to evict any tenant if no offense has been committed and then bring in another tenant. When it comes to eviction, everything has to be specified in the tenancy agreement. So that in the tenancy agreement, there are some basic requirements or some basic information that has to be there. The tenancy agreement, being a contract, needs to have the information of the landlord, needs to have the information of the tenant, being its contact number, its address, and anything that can be used to identify that landlord or tenant. We also need to specify how much the tenant has to pay within that period. And then the frequency of payment. The issue about rent is that you can sign a tenancy agreement with the tenant for a period of how long you want. It can be 1 year, 2 years, 3 years, so long. But when it comes to the payment, when you look at the Rent Act, it mandates that if it's a short tenancy means it's a monthly payment, then you don't have the right as the landlord to charge more than 2 months. And then if it's a long tenancy, just as I mentioned, you can sign an agreement for 4 years with the tenant. But when it comes to the payment, you as a landlord has no right to demand or receive more than 6 months rent from any tenant. So if it's a 4 years, then every 6 months, if that is what is agreed, every 6 months the tenant will pay. This is the frequency of payment. Then within the tenancy agreement again, you have to get witnesses who has to witness what you are doing, so that at the end of the day, in future when there's a grievances, those 2 people can come and testify. Then the responsibility of the tenant as well as the responsibility of the landlord has to be specified. Who is responsible for this kind of maintenance, who is responsible for this kind of tenant maintenance has to be specified there. So all these things must be there, so that when in future something happens, you can stand on this and then adjudicate any case that comes before us. So as I mentioned, when it comes to the frequency of payment and then the duration of payment, the law under section 25(5) states that any person as a condition of grant, renewal or continuance of a tenancy demands, in the case of monthly or short tenancy, the payment in advance or more than a month's rent, or in the case of a tenancy exceeding 6 months or long tenancy, the payment in advance of more than 6 months shall be guilty of an offense and shall, upon conviction by appropriate rent magistrate, be liable to a fine not exceeding 100 penalty unit, or which is equivalent to 1,200. So what we realize is that the education to this aspect is being lacked by both landlords and tenants. So we've intensified our sensitization. So what we are seeing now is most landlords have started adhering to this and going away from the 2 years and 1 year. So what we've mandate tenants to do, or prospective tenants to do, is that when you get to any premises and the landlord demands, which constitutes an offense, or even collect, you first have to run to the rent control office and then report that case. Because through this, that we can take off, or we can scrap all those landlords who are charging more than 6 months with the current act. What is interesting is that there's a bill before cabinet which are saying that the money that is put in building is increasing. So there is a proposal that these 6 months will be increased to 1 year, which means if it's a short tenancy, you will be mandated to collect monthly, and if it's a long tenancy, you will be mandated to take a maximum of 1 year. And until that law or bill is passed, we are maintaining this 6 months, and we are charging or urging all landlords who have not started collecting these 6 months to start adhering to it, because we started prosecuting most landlords, we started sanctioning them. What is interesting too is that all landlords who have come before us and we've cautioned them have not come back with this offense of charging more than 6 months, which means they were not aware, and some of them have started adhering to this provision. So with the issue of rent increment, the law or the act states that it's only the rent control officer or the magistrate who can increase rent, and the mentioning of the assessment and the issuance of the assessment certificate. The assessment is done every 2 years, which means that the certificate is issued every 2 years. So as a landlord, you don't have the right to be increasing your rent every 6 months, because the act states that you have to charge 6 months durations. So as a landlord, until the 2 years expire where you apply for another assessment, where we'll come and see whether an improvement has been made on your premises. If we come and we see that your premises is deteriorating without you maintaining it as well, we have the right to reduce the rate that we give initially or 2 years back. But what is pertaining is that if you charge 6 months and no assessment, no improvement has been made on your premises, you then don't have the right to increase your rent after the 6 months. You have to wait till the end of the 2 years. You apply for an assessment, and then we'll come and see, based on the rates that you are paying and other issues, if we warrant that we have to increase the rent for you for another 2 years, we do. But it's not mandatory on you as a landlord, because the tenant pays 6 months. The next 6 months, you have the right to increase. No, you don't have the right if no improvement has been made. It dawns on the rent control officer and the rent magistrate to increase rent of any premises, and not the right of any landlord. So on the issue of maintenance, there are 2 categories here. What is general pertain is that everything has to be specified in the tenancy agreement as to the responsibility of the maintenance. But if this does not come in, then the interior of the premises dawns on the tenant, since he or she is in the premises, to make sure that as he came to meet the premises, he maintains that. If it comes to socket, painting, and then basic maintenance work, it's the responsibility of the tenant. If it comes to major maintenance, like the roofing, outside wall, and anything outside the premises, it's the duty of the landlord. It can come, as I mentioned, that everything we specify in the tenancy agreement. If our responsibility will be shared or it will be a responsibility of the landlord, then it will be, in effect, it will be in the rent, so that some money will be allocated to the landlord for him to use to maintain this. But as I said, the interior maintenance is the responsibility of the tenant, and then the external is the responsibility of the landlord. So when it comes to the visitation by a landlord to any premises, it dawns on the landlord to give ample notice to the tenant as to when visitation will be made. This is done for the landlord to ascertain whether the structure is being deteriorated or the tenant is not maintaining the premises well. But in all cases, the landlord has to give the tenant ample time or a notice for the tenant to prepare. So as a landlord, you just don't wake up and then say, I'm going to inspect my premises. No, you have to give the tenant a time, and then you have to agree for the tenant to be available for you to come and inspect the place. This brings the issue of landlord having keys of premises they've rented out. You don't have the right to go into somebody's, so far as you've rented the place out, You don't have the right to be visiting as and when you want. So landlords should desist from going to any premises of theirs which they rented out. They have to give notice to the tenant. And it for security reason, it's also advised that as a tenant, when you move into somebody's premises, the first thing you have to do is to change the lock, so that if the landlord has another spare key, he may not enter your premises when you are not available. So that when you change the lock and you are moving out, you are vacating the premises, you bring back the lock that the landlord gives you initially. So this is an advice to tenants who have rented people's premises. So on the basis of advice, as we continue, what we want to advise prospective tenants in particular, that when you are going to rent a premises, don't go there with hesitation that I want this premises. What you need to do is, if you are shown the place, go back and then do some underground investigation as to the nature of the environment, be it an earthquake zone, a flood zone, and all those things. And especially, make sure that the person who is calling him or herself a landlord or a landlady is the rightful person. We've seen instances where people post as landlords and landladies, people pay monies to them, and then at the end of the day, the rightful owner will come and then claim that the building belongs to him or her. So you have to do this due diligence before you depart money to anybody who call himself landlord or landlady, and especially to the agents who sometimes also pose and then show sumami, as we call in the local parlance. Those who look after some places, then they pose as landlords and then collect money, and at the end of the day they run away, and then when the rightful owner comes, you can't trace them. And then on the part of the landlords, there are documents, as we mentioned. This rent card has information. So the information that we require here is the information of the landlord, and then the information of the tenant, and then we have an emergency number portion, name and portion. This is provided so that in case the tenants run away, you can fall on somebody to trace where the tenant is. Also, when something happens to the tenant, you as a landlord can call somebody as an emergency to come to your aid as far as the tenant is concerned. When you look within the card, you can have 4 portions. Just as I mentioned, you can sign an agreement for up to 4 years or beyond with a tenant. But when it comes to payment, if it's a short tenancy, it's monthly that the law mandates you to collect. If it's a long tenancy, just like the 4 years you have, the maximum will be 6. This card come in pairs, so the landlord will have one and the tenant will have one. And then the issue about tenancy agreement. The first thing as a landlord, you have to give to a prospective tenant is the tenancy agreement, for the tenant or the prospective tenant to know his or her rights and responsibilities before he gives you any money. So when you give it to the prospective tenant and the tenant agrees and signs, then it binds on the two of you. That's where after then the tenant will give you money. And the law mandates that instantly when the money is given to you, being anybody who gives you the money in respect of the rent, instantly you have to issue a receipt. If you don't have a receipt, you can take a paper, write all the details, amount, who gave it to you, the date and the purpose on the paper. Then later you can issue an official receipt to the person. Also, as a landlord, any rent that you collect, the law mandates under Income Tax Act 115 that you pay a rent tax. The rent tax varies or is in 2 categories. The first one, if it's a residential, you pay 8% to the Ghana Revenue Authority, and if it's commercial or for business purposes, you pay 15%. So these are basic things that every landlord should have in his or her hand. Then we come to the issue about agents. The law recognizes agents. The recognition there is that as an agent, is the landlord who has contracted you to look for somebody to come and occupy the premises. So it dawns on the landlord to give you a commission and not the prospective tenant. because the tenant has not contracted you, is or she is looking for a premises. So when it comes to the payment of the commission, it's the landlord who has to do. And it happens only when the tenant has agreed to stay in the premises and has made payment. And that payment goes to the landlord. The landlord takes 5% of the rent. And I state again, 5% of the rent as a commission and give it to the agent. So as an agent, you don't have the right to collect any percentage from the landlord, any percentage from the tenant before you give or you show the tenant any premises. It's after the money or the rent has been handed over to the landlord that the landlord will take 5% of that amount and give it to you as an agent. So going back to our advice, what we tell every prospective tenant is that when somebody show you a premises, make a due diligence and then make your investigation before you depart any money. Somebody will pose as a landlord or as a landlady, or you know that person is Shawamami or an agent. So you have to do due diligence. Definitely where you are going to stay will not be an isolated place. So you can ask around and find out the real owner of the place. And secondly, the 5% or the 10% that the agent charges is illegal. So when something happens, you just run to the rent control department because it constitutes an offense which is contrary to the act. Such people, we just prosecute them before the magistrate where the sanctions will be done. They can go to prison, as I mentioned, to a maximum of 6 months and a minimum of 3 months, or can be fined 1,200 maximum, a minimum of 600. So any person who an agent has duped you or defrauded you, you come to the rent control department. Some of these issues also constitute a criminal offense. So if you see it as a criminal offense, go straight to the police and then make a report where they will trace, because it's fraud. If you don't have anything and then you sell it out, you don't have anything and rented it out, constitute an offense, constitute a fraud, you just go to the police for them to do their investigation, and if any prosecution will be done, they will do. As I mentioned earlier, the rent control department is also mandated to maintain 2 registers. The 2 registers, namely the vacant premise register and then prospective tenant register. The vacant premise register is where a landlord, after an assessment, will put that information into our database, or a landlord can walk into our premises and tell us that he has vacant premises based on the structure. And then the second register is the prospective tenant register, where people roaming about looking for an accommodation can also come. And based on the location, if you come as a prospective tenant and then we look into our database and then what you are looking for suits any of the registered vacant premises, we just call the landlord, call you as the prospective tenant, and then link the 2 of you to go and do the necessary documentation. So any landlord who has any vacant premises can walk into our premises or can as well get to this agent and then give them for them to get any prospective tenant to come and occupy the place. But talking about agents again, the bill that has been laid before cabinet is going to seriously regulate these agents. What it's going to do is that there are 2 bills actually. We have the real estate agency bill and then the rent bill. These 2 bills will work together to make sure that all agents are trained and registered. And then their name will be published frequently so that any prospective tenant who wants to deal with any of these agents will go through the list and see the accredited agents and deal with them. So the issue of people defrauding prospective tenants as agents will be wiped off. So as a prospective tenant, if you go on the list or you go on the website and you deal with any person without the person having accreditation, it will be on your head, or it will be your own issue. Always when that bill is passed, we make sure as a prospective tenant you look through the list and then deal with accredited people who have been trained and has been certified and has been given certificates. Okay, so our final advice to landlord especially, as we've continued to mention, there are 5 basic things you have to do as a landlord. The first one is that when it comes to your building and you finish your building, you want to dwell in personally, the rent act does not inflict on you. But when it comes to mind that I want to rent this place out, I want to put these premises on the commercial premises, the first thing is for you to apply for what we call the assessment of recoverable rent. After the rent officer has come to your premises to ascertain whatever material, the location and everything that you use in building your premises, the officer is mandated to give you what we call an assessment certificate, within which we will state how much you are supposed to charge for the 2 years period of the assessment. Then when you get this certificate, then it dawns on you to do advert. You can do the advert through the rent control department, through our vacant premise register, or contract any agent to look for somebody to come and occupy the place. If the person comes and the person is interested in your premises, the first thing you have to give the prospective tenant is the tenancy agreement, for the prospective tenants to know what needs to be done in the premises, what requirements are needed in the premises, what his responsibilities will be in the premises. So after the tenant has signed that tenancy agreement, the tenant will give you money. The law mandates you that you give instantly a receipt to the tenant. After the issuance of the receipt, you have to go to Ghana Revenue Authority to pay your rent tax. After your rent tax, within 7 days, you have to come to the rent control, and then you buy what we call the rent card, where the details of the landlord, the details of the tenant will be there, and then the mode of payment will be there. On the part of the tenant, what we are saying is, when you want to rent any premises, do due diligence and make sure that where you are going to rent is habitable, and that there is no earthquake, there is no flood, and you are paying the money to the rightful person. And then on the part of the agent, the law mandates that you are not supposed to charge more than 5%, and that money has to come solely from the landlord and not the tenant. So basically, these 3 people, these are the advice we want to give you people. Let's all abide by it. And then the landlords again, when you are charging more than 6 months, you are not helping us to make sure that the housing deficit comes down. The explanation there is that if you take more than 6 months, if you take 2 years, then the person who is coming will not be able to start something, will not be able to buy a land, will not be able to start building, so that when he lives in your premises for a period of time, he can now boldly say, I'm now going to occupy my own occupancy. So every 2 years, you force the tenant to pay 2 years without giving the person the chance to also start something. So let's all abide by the regulations, that is the act, so that we can live peacefully in the country.